In this recording, we're going to look at the executive and where it sits in the three arms of government. And so the first slide I just want to draw your attention to is the one in front of you with the executive arm, in the very literal sense, arm of the tree, arm with the chainsaw, chopping off the other two. Why is that? Why does the executive hold a special place in relation to the three arms of government? Well, really, it's because the executive is the source of ultimate power. Going back to the age of absolute monarchies, there were no other arms of government. It was only the king. And so this famous quote from one of the French kings, "I am the state," really ties into the idea that the executive is about doing things. It's about enforcing the laws. And really there's an inherent political dimension to the executive. And thus the formal definition in the slide here is that the executive or executive power is the power to administer the state, to enforce the law, and to implement essentially government policy, which has a very strong political dimension to it. Now, a more formal, structured definition of the executive is how it's defined within the various constitutions. Certainly in Section 61, it's stated in very broad terms that executive power in what would have been the new Federation of Australia is vested in the Governor-General, herself or himself, as being the representative of the monarch. And similar sections exist in the constitutions of the states and territories themselves. Now, while this is a very dry and quite simple explanation of it, it really doesn't do much justice in terms of explaining what the underlying meaning or purpose or role of the Governor-General and how much impact they ought to have in the system in terms of actually doing things. It's a very, very broad expression of what the executive is. And one of the reasons why it's so difficult to really come to grips with what the executive actually means and what it is that it's a lot harder to pin down than the other two arms of government. I mean, it's quite easy to sort of look at a courthouse, a courtroom with a judge in front of it and see that that's an institution of judicial power. And the Parliament, similarly, as bodies, they sit in a certain place and they have that recognition. Whereas the executive arm of government is a little bit more fluid. And so in this recording, I'm just going to go through what the executive means and its various sort of concepts and manifestations, beginning first with the idea of the crown. And the concept of the crown is really an abstraction. It's that idea that there is this indescribable, intangible sovereign who has complete dominion over all subjects of the realm. The slide, in fact, the picture there is taken from Thomas Hobbes' famous treatise on this, on the social contract, called the Leviathan. The idea that the crown, the all-powerful sovereign, rules the land because we each cede our personal sovereignty to her or to him. And so this idea of the crown as this abstract concept, and also as something symbolic, the idea of the crown itself, be it represented it as a physical object that the Queen of Australia in Windsor Palace places on her head from time to time, or the idea of having the seals, the various states, territories and the Commonwealth government have the coat of arms. This symbolism that demonstrates what the crown is not just necessarily an expression of executive power, it's also incorporated in the two other arms of government as well. So for example, when entering a courthouse, the seal of the state or of the Commonwealth is seated behind the judge or magistrate, and one is to bow to the seal rather than to the judicial officer. Similarly, judges, when presenting judgments, they essentially are representing themselves as doing things on behalf of the Crown. Prosecutions are structured as being the Crown against the accused, in that it's the state that's bringing the action in the criminal law. Similarly, in the Parliament, the symbols of the monarchy and the regalia are all on show when Parliament's opened, for example. Also, the Governor-General herself or himself actually forms part of Parliament. That it's that idea that the Crown needs to assent to things. This idea of the Governor-General, the Governor in the States, assenting to legislation that's been validly formed in order to perform that final step of legitimacy. And so really we have this abstract concept of the Crown, and in many ways it's analogous to the executive itself, or a representation of the state, or indeed of the government of the day as well. The Crown doing something, bringing something, being something all-powerful. Now, when we think about the actual monarch herself, at the moment, Queen Elizabeth II, Queen of Australia, you'll note that the Queen has a lot of formal power. In other words, if one were to go and read the Australian Constitution, there are many references to the Queen. Now, it's interestingly or incidentally, the Queen is described in the Australian Constitution. They use the actual word Queen. That's actually referring to Queen Victoria, who was the reigning monarch at the time the Constitution was passed. But it's clearly described that reference also includes all of her heirs. Now, and again as a thought experiment, this can be useful, if aliens were to land and were trying to work out our system of government by reading our Constitution, it wouldn't be unreasonable to think when perusing this document that person has an amazing amount of power. And again, reading that document, there are a lot of formal powers that are listed as being the direct domain of the monarch. However, in practice, these are never used. So that in reality, in terms of what we recognise, the Queen has this formal power in our constitutional arrangements, but no substantive power, and that she doesn't do anything in relation to our legal and political system. Similarly, the Governor-General and the governors in the states also have these reserved powers. They have these listed powers as the Queen's representative to go through and do all of these things. However, by convention, by tradition, the Governor-General and the governors in the states don't use these powers. It's just something that isn't done. However, on one very famous occasion, the Governor-General of the day actually did use their power to dissolve Parliament in that case. The Whitlam crisis in November 1975, where the Governor-General famously sacked the Prime Minister and appointed the Leader of the Opposition as caretaker Prime Minister until an election could be called. This essentially was unheard of before and after that particular time. So I guess it's helpful to just note and just to remember that while the Governor-General ought to take advice from the government of the day, that doesn't always happen. Many commentators do, however, suggest that if there was to be a repeat of 1975, that Australia would probably very quickly transition to becoming a republic. And one of the reasons for that is that having a republic and having a president, which may or may not be elected, is that it would more carefully map out what that person can and can't do, and actively set out a framework to, I guess, to give power and also to limit power in certain ways. And many commentators believe that that's a far more appropriate mechanism. However, our system, by and large, again, barring this one quite glaring exception, has operated and worked for a very long time. Now, one area where the Governor-General takes a role is in what's known as the Executive Council. That's essentially the Governor-General plus the Cabinet. where the cabinet is making political decisions, government decisions, and where power has been vested to the Governor-General to perform particular acts, then she or he is to, I guess, seek advice, but essentially just do what they're told. So when thinking about executive power, again, perhaps it's useful to look at the underlying realpolitik. Who is the executive and who actually vests the power to do things, to make changes, to apply the law? And really, that's fundamentally cabinet. Cabinet being a collection of the senior ministers, the ministers being a collection of MPs in both the lower house and the Senate in the federal system, and there's only one house in the state of Queensland, but the majority of MPs in those systems is the one who forms government. A really important manifestation of the executive and the government is the statutory bodies. These are things that are created by one or more pieces of legislation and given discretionary power. That is, given the power to make decisions. These statutory bodies are quite varied, and I guess the most important ones when we think about the executive are government departments. Now, we've actually encountered the second of these, local councils, earlier in these recordings under the legislative part. Why? Well, councils are usually elected, voted for, and the process for choosing those representatives is done quite similar to how we elect Parliament. But strictly speaking, local councils are actually part of the executive. Why? Because they're creatures of statute. They are created by Acts of Parliament, given some form of discretionary power, most importantly, to run the affairs of small areas, and given the power to create delegated legislation to do with those areas. So strictly speaking, they're actually part of the executive arm of government. Now there are some other statutory bodies that are I guess a pretty important in our system of governance. The Auditor-General goes and checks up on government departments. In other words, the Auditor-General is actually a statutory body which reports directly to Parliament, and it's kind of a bit of almost like a telltale in that they're going through independently checking on government departments to make sure that they're actually doing and following what the legislation that gave them the power in the first place actually involves, to make sure they are following Parliament's intent. Now, similarly, the Ombudsman is a statutory body that's created for citizens to request that particular matters or complaints are investigated. So that rather than looking at the integrity of the of government departments, it's usually following up what's happened in particular cases. And so the Ombudsman, again, is a statutory body that reports directly to Parliament. It's not a separate government department per se. And their role is to report. Essentially, it's a one-way process. They don't actually really do anything other than refer the matter to the various government departments, or in some situations, report things and findings directly back to Parliament, particularly when things are problematic. Ombudsmen have been set up and established, sometimes with particular industries in mind. For example, the Telecommunications Ombudsman is an entity which reports on complaints that are made when media organisations don't follow the particular statutes that they're supposed to. Similarly, there are ones for banking, insurance, and so on. Now, another, I guess, important branch of the executive is the police. And so if there was ever an entity which really expresses or manifests the doing, the executing of the law itself, it's the frontline troops, for want of a better expression, the people that are responsible for public order in society and for bringing about the vast bulk of criminal prosecutions. And again, the police are given discretionary power to go to find evidence, to charge people. They're given discretionary power to arrest people, and how this power, this discretionary power used, is very carefully mapped out these days in legislative instruments such as the Police Powers and Responsibility Act. Now, another a very important part of, I guess, that of executive power, which doesn't seem like it's a part of the executive, is tribunals. Now, tribunals are set up in a wide variety of circumstances for them to exercise, in many ways, a quasi-judicial function. And it's important to note at this stage, tribunals are not courts. Often in tribunals, the rules of evidence don't apply, and tribunals in most circumstances don't have the power to hold citizens in contempt of those proceedings. Generally, tribunals are bodies that are set up for one or more parties to come, present some evidence, usually in an informal, less formal structured way than a court, in order for determination to be made. For example, taxation matters, where there's a dispute a citizen has with the tax office, that can go to a tribunal in order for the two sides to bring some evidence and the tribunal to make a decision. Now, this is not necessarily a judicial decision in the sense that it's an order punishable by, again, by contempt for those that don't follow it. Tribunals are really, I guess, in many ways, a low-cost alternative where a decision needs to be made, but for whatever reason, we don't want, in the circumstances, matters to go through the time-consuming and expensive and, I guess, very structured court system. Now, another area to look at are privately owned bodies or partially owned entities that have quasi-government functions. So, for example, this would include things like Telstra, where the government still has some stake in that particular body, or where a government entity has outsourced a particular function to the private sector. Now, the reason why this sort of falls under the scope of the executive arm of government is because often those bodies that are performing these particular functions, and often said they're sort of business functions, they can be day-to-day things, so providing telecommunication services, which isn't really a core government function. But fundamentally, it's a political decision. It's a decision of the executive to put these things into motion. Now, there is and have been quite a lot of judicial commentary on when things are outsourced to private individuals, whether or not that forms part of the executive arm. And that area of law is still developing to this day. Really here, what I'd like the listener to really think about and to take away from is that idea that the executive makes decisions, usually political decisions, and carries these things out. And the further afield that goes, in terms of doing things in the private sector, getting non-government actors to do that, the further the distance is from the original decision, the less part of the fold, less part of this executive arm of government that particular process is going to be. One of the key powers that statutory bodies are often, but not always, given is the ability for them to create their own laws. This is known as delegated legislation, and the words we use to describe the different types are often regulations, which is the most common, but also you may from time to time hear the words rules, bylaws, ordinances, standards, codes, and determinations. So fundamentally, these things are law, in that Parliament has given power to another body to make usually subordinate rules that have the full effect of the law. It's as if Parliament were to pass it themselves. Now, delegated legislation is a very important part of our system of governance, largely because the amount of sort of rules and regulations that contemporary Australian society requires in order to function is vastly more than what Parliament has time to go about actively legislating. Again, in earlier recordings, we looked at the parliamentary process, and you may recall, it's really thorough. It's very, very time-consuming. There's a lot of scrutiny. There's a lot of process. And so delegated legislation exists to really fill the void, the very, very large void, for when Parliament simply hasn't got time to effectively map out particularly small regulatory issues. It's really important to note here a couple of things. First of all, that by default, delegated legislation can't trump the original statute. Parliament clearly maps out and defines in, the head statute, what the statutory body is actually allowed to do, giving them essentially the powers to legislate, but only within a narrow range. Now, often, particularly where there are offence provisions, the head statute will say, well, we're going to give power to a statutory body, for example, a local council, to enforce certain offence provisions. An example might be for, say, parking one's car. The council, for example, the Townsville City Council, can pass delegated legislation and bylaws for the Townsville region. And if one goes back to the original statute passed by the Queensland government, the original statute might say, look, you can pass these laws and you can specify, say, a maximum fine for parking infringements of, say, 5 penalty units, which may be about $600. The Townsville City Council can then take that, create these bylaws, pass them through the procedure that is specified in the head statute, but the council can't create offences with a larger penalty in that case. And often they don't even come close. Say, for example, they may wish to have 1 hour parking, and if you park over for longer than that, you'll receive maybe, say, a half penalty unit penalty, around about $60. So the power, broad power, was given by the statute to legislate over a particular area, and the subordinate delegated legislation and the body doing that can't trump the original statute. However, from time to time, for certain reasons, Parliament will give the power for statutory bodies to actually create their own laws which can go outside the scope of the original legislation. These are known as Henry VIII clauses, after the quite infamous King of England, who was really trying to, and however he possibly could, to usurp as much power, take it away from the Parliament, and give it back to himself. Now, these Henry VIII clauses are really problematic in terms of governance. Why? Because it's really giving broad powers to the executive arm of government to go about making things that may or may not be intended by Parliament. Often these clauses, by the way, are structured in such a way to have sunset clauses in them, or a certain period in which that particular statutory body can go about making these types of laws. They, until relatively recently, the last 30 or 40 years, were very rarely used in Australia, and slightly unfortunately, in the last 10 to 20 years, the use of Henry VIII clause has actually increased, and certain law reform bodies have really sort of pointed this out and say, hey, look, this really isn't a very good idea, giving discretionary power to create laws to the executive arm. Because traditionally, Henry VIII clauses were really only used in emergencies, in times of war, often. There's just one other thing I want to note about delegated legislation is that delegated legislation and the creation of bylaws and regulations and such like is fundamentally different from policy. And this can be an important consideration, again, for those that are seeking entry to the legal profession when looking at systems of review. Why? Because from time to time, government departments will do things and make decisions in certain ways based on policies. But fundamentally, those policies are just political decisions that have flown from the higher powers that be, the minister often representing party politics. And I think it's helpful conceptually to just remember the fact that policy is really plans or ideas of things that a particular person or group of people want to eventually make law, but they're not actually law themselves. They're really statements of intent. And that really leads into the final point to do with transparency and accountability, because decisions of government and decisions made inside cabinet aren't transparent at all. They're both private and they're very political in nature. And so part of having a contemporary system of governance is to really try and find mechanisms to offset and curtail this absolute, arbitrarily, almost whimsical method of governing our society. And so that there are some checks and balances in our system that can curtail this in some way. And it may be really helpful to think about these as methods of, I guess, restricting the absolute power of the executive arm of government. So the first of these is the idea that ministers are always MPs. Now, interestingly, this is actually a constitutional requirement in the federal parliament, and that ministers have to either be in the House of Representatives or in the Senate. However, it's done by convention in the states, certainly in the state of Queensland. Why is this curtail of the absolute power of the executive? Well, it means that ministers are in some ways responsible to the people. If the executive arm of government makes some poor decisions, they can be voted out as individuals. Sure, there's a bit of lead time on that. You have to wait until the next election. But in some ways, that idea of not having a strict separation of powers, like they do in the United States, actually gives a little bit more power back to the citizen in terms of preventing this, again, this arbitrary use of power. Another check in our system is question time. Again, because ministers are always MPs, when the minister is in Parliament, a certain amount of time is allocated for usually members of the opposition to actually ask questions of the minister, and they're obliged to respond. And so in some ways this offers some scrutiny of government departments, because there's a bit of naming and shaming that can go on in that process. Another mechanic that we have in terms of offsetting this very, very opaque decision-making process is freedom of information. Again, this is a relatively recent phenomenon. The idea that the citizen is entitled through statutory mechanics, the Freedom of Information Act in the federal jurisdiction, and in each of the states they have their own FOI legislation as well. The citizen is entitled to receive security sensitive information on decisions made about them. So a person can contact their government departments and actually make one of these requests, and those government departments are obliged to provide this information within a reasonable time frame. Also, another check and balance in our system is the very strict separation of powers that the High Court has expressed in a series of cases to do with Chapter 3 courts. Now, Chapter 3 of the Australian Constitution, which sets up the federal judiciary, and also gives power to the state courts to determine issues of federal jurisdiction, The High Court has actually said that Chapter 3 courts are, as repositories of judicial power, can only be repositories of this power. This flows from a case that I've mentioned in earlier recordings, the Gregory Wayne Cable case. These are known as the Cable Doctrine. And it's important because what the High Court has said is that, look, Chapter 3 courts can't merely be a mouthpiece of the executive arm of government. They can't just be regurgitating what the government of the day wants them to. Courts have to be able to make their own decisions. And in theory, be free of this political dimension when doing so. Another check in our system that I alluded to earlier is the Auditor General and the Ombudsman actually not being government departments themselves. They're statutory bodies, sure, but they report back to and are funded directly by Parliament itself. They're not government departments that are subject to direct political decisions of cabinet. Whereas most government departments that have a minister at the head, well, the minister is ultimately a member of cabinet, and thus decisions that she or he makes are going to be political ones. Finally, and most importantly for those seeking to continue their legal studies, is this area of law known as administrative law, and that's that idea that decisions of the executive must be made according to an appropriate amount of due process, where decisions are made that are either beyond the scope of the governing law, the head statute that gave that body the power in the first place, or haven't followed the rules of natural justice and procedural fairness, or where a decision maker has made really a very bad decision in terms of weighing up the evidence. Where these happen, a citizen is entitled to actually go to either the courts or to the tribunal and have that decision reviewed. And this is a really important aspect in our system because it's really giving power to the citizen to make the executive arm of government accountable through the mechanics of the courts themselves. So in conclusion, this recording, which is focused on the executive arm of government, is really designed to give a broad, conceptual, high-level understanding of what the executive is. Unlike the other arms of government, it's difficult to pin down. However, it's helpful to remember the executive, who originally was just the only arm of government when we had absolute monarchies, is given discretion to do things. The executive executes the law and does things, carries things out, and must make discretionary decisions when doing so. We have checks and balances in our system to stop them from really acting like the kings of old and making capricious decisions that impact us as citizens and really undermine our entire system of governance.